Pues muy buenas tardes. Good afternoon. Thank you very much for coordinating this very interesting workshop. And I said that most of the Mexican lawyers have studied a kind of caricature of Professor Kelsen's thought, but we proudly call ourselves Kelsenians. With the arrival in Mexico of new legal philosophers, especially from the Anglo-Saxon analytical school, the thought of Professor Kelsen was relegated to the hall of the fame without even having been properly understood. I thank Dr. Jorge Fabra and Gonzalo Villa-Rosas for coordinating this excellent workshop, and I thank very much the speakers for allowing Mexican researchers, professors, and students interested in the legal philosophy of the opportunity to come into contact with true Kelsenian thought, thanks to some of its greatest international representatives. Thank you very much. Okay, Jorge, Gonzalo, cuando quieran.
Gonzalo?
No, you are in charge first.
So hello everyone, thank you so much and welcome to this book launch of Kelsen. I have a brief presentation just to start us, and I would like just to begin. I have entitled this presentation "An Invitation to Kelsen," to this book. So, okay. So first of all, this is the culmination of a couple of years of work. We all have been, many of the authors, it's a pleasure to see them again. And we're really happy to see this volume and to see this work in finally becoming a reality. And I would like to preface these presentations by asking a question: why revisiting Kelsen? Enrique's word reminds us that a saying that we used to have, like, we didn't study law in Latin America, we study Kelsen. But why do we have to write another piece? And I think that Kelsen is inevitable in certain ways. Kelsen wrote virtually in every area of legal thought. And by revisiting Kelsen, we are revisiting the foundations of many aspects. And many years ago, we organized a workshop in order to discuss once again Kelsen's legacy. It was organized under the auspices of Juris North. And in that workshop, we discovered, and we knew again something that we already know, that Kelsen is a genuinely global jurist. That in that meeting a couple of years ago, we have individuals from virtually every corner in the world, from Canada to Australia, from Argentina to Russia, passing through Germany to Barbados and so on. And the thought of Kelsen is not a discussion of all ideas. As this presentation will show, many Kelsenian themes, many topics that Kelsen discussed, such as democracy, the very idea of law, international law, have a new currency in our events. So this presentation is basically an invitation for the readers to join us, potential readers to join us in exploring this fantastic volume. The volume has 4 components. First, norm theory. Second, international law. Third, democracy. And 4, a discussion of Kelsen's legacy. What I'm going to do very briefly is just to go over the quickest of summaries of this volume, and then we will let the authors speak for themselves. So there is something going wrong in the presentation, but the first parts are preliminaries. The introduction of the book is done by Stanley Paulson, the Dean of Kelsen Studies, and we have this fantastic introductory study by Gonzalo Villa-Rosas. I'm so proud of having the chance of working with Gonzalo. He's one of the smartest guys I know. He wrote an excellent introductory study. The first section is about legal norms, legal normativity. We have a contribution by Stanley Paulson on Bullying's Kelsen, Robert Alexi on the idea of relative a priori. Professor Iain Stewart, who will join us, who is here with us, had an excellent piece with historical detail about Kelsen doctrines entitled Kelsen the Outsider. Professor Carsten Heidemann have an excellent paper on legal validity, and Julieta Rábanos will present some force and effectiveness. The three are with us today. The second part of the book is about international law. Unlike Hart and Ras, Kelsen was a theorist who took international law seriously. From this section, Professor Phil Edwards will discuss the idea of primitive law in the work of Kelsen. The third section is about Kelsen thought on democracy. Unfortunately, Professor Mónica Zalewska cannot join us today, but we have Professor Lars Vinx from Cambridge University talking about Kelsen thoughts and the currency of Kelsen thought on democracy and in the light of authoritarian and populism tendencies throughout the world. And the final section is about the legacy with Rodrigo Cadores' book chapter on the Vienna School and the influence on Kelsen, Asia Austruck on Kelsen influence in the Granada court and how Kelsen informed this specific debate about revolutionary legality in Granada. And finally, Professor Mikhail Antonov, who is not able to join us. He excused himself. So I would like to conclude with a couple of thoughts. Number one, it's an invitation. This presentation is just an overview of the book, and the presentations that follow will present the key arguments. So it's an invitation for all the potential readers to join us in this journey with Kelsen. And for us, the editors, and I hope also for the contributors, it's a feeling of mission accomplished. It's been a long journey. The book has been revised many times, and I apologize for our continuous revisions, and I thank the patience of our contributors. This book has just a final note. It has a dedication to the memory of 4 individuals who contributed to Kelsen work, to works on Kelsen: Ernesto Garzón Valdez from Argentina and Germany, Maria Teresa Lopez from Argentina, John Garner, Eugenio Buligin, and Roberto Bernengo from Argentina. And I would like just finally to thank J.M. Giraldo for the fantastic cover, and there is this beautiful design with the John Kelsen and an older Kelsen in the back that he generously donated for our volume. Having said that, thank you so much to everybody for being here, and I will leave Gonzalo to moderate the rest of the session.
Can you hear me?
Yeah.
And you see the PowerPoint?
Yes.
Okay. But I'm not sure if you are seeing the right PowerPoint. Wait a minute. I have a small confusion here. Now you are seeing the PowerPoint, I think. So thank you, Jorge. Good afternoon, everybody. Thank you all for joining us today for the launch of this book. One moment. Okay. For the launch of this exciting and thought-provoking book, it is an honor to present the program for what promises to be a remarkable event filled with insightful discussions and experts' views. Our event will be divided into 2 sessions. At the end of each session, we will have the opportunity for questions and comments. The first session will feature the following professors. We'll hear from Iain Stewart, who will speak on Kelsen the Outsider, Carsten Heidemann, who will explore the varieties of validity. Julieta Rábanos will present her talk on force, effectiveness, and law in Kelsen. We will have a short Q&A session to discuss these fascinating topics. The second session will feature the following professors. Lars Vinx will share insights on Hans Kelsen's and the crisis of democracy. Phil Edwards will close the presentations with Kelsen and primitive international law, 3 solutions and a problem. Finally, we will have another round of questions to engage with our speakers. And now I hand over to Professor Iain Stewart, who is associate professor at Macquarie Law School. Professor.
Thank you very much indeed. Can you hear me?
Yes, Professor.
Thank you. I express my gratitude to the editors of this exceptional volume for inviting me to speak at this launch, and to the organizers of this illustrious gathering for permitting me to speak in English. I can read Spanish a little bit, but I cannot speak it. The following summarizes my chapter in the book. Firstly, Kelsen's late turns. In the preface to the second version of his Rechtslehre, which would be the final full statement of his pure theory of law, the almost octogenarian Hans Kelsen avows that he's laying down his pen. The book, he says, is to be regarded not as a presentation of final results, but as an enterprise needing to be continued by supplementation and other kinds of improvement. It would have achieved its aim if continuation of that enterprise were to be considered worthwhile by others than an author already at the end of his life, he says. That might be taken as just a farewell gesture, but this old man would not keep still. From 1962 to 1965, he made 3 major corrections to the pure theory, which I will refer to as turns: a constitution turn, a logic turn, and a fiction turn. In the constitution turn, a specifically constitutional sector is removed as unnecessary from the concept of a positive legal order. Instead, every relatively higher norm is to be a constitution in relation to a norm below it, but no change of principle is involved. The logic turn does involve principle. In 1962, Kelsen instead holds that the laws of logic are entirely inapplicable to norms, even by analogy. All that can be said about the norms themselves is that they conflict. The constitution turn and the logic turn could be regarded as belated refinements of the pure theory, not so the fiction turn. How was it that during a balmy night of August 1962, in a congenial environment of the 17th century hilltop residence in Salzburg, Hans Kelsen suddenly informed a small workshop, which he knew to be composed of opponents and even enemies, that he had been talking fiction? The workshop organizers have published not only the papers presented, but also a verbatim transcript of the discussions. This has made it possible to examine the proceedings as a socio-historical event. I find that the invitation to Kelsen was a setup. His intellectual arch-enemies, conservative Catholics, had hoped to record catching him out for the benefit of their version of natural law. In the course of discussion, however, Kelsen announced out of the blue that he would now speak of a basic norm not as a hypothesis, but as a fiction, and moreover a kind of fiction that involved not only falsity, but also self-contradiction. He would elaborate on this slightly 2 years later in a paper for a conference in Vienna. Kelsen confesses that a basic norm cannot be simply the meaning of an act of thinking. It is a kind of norm, and a norm is the meaning of an act of will, which is to suppose a willer. Even to suppose an imaginary norm is to suppose an imaginary willer. Therefore, the idea of a basic norm as an act of thinking without a willer is self-contradictory. It is not a hypothesis, as he had long maintained. It is a fiction, in an extended sense that he will eventually attribute to Hans Feiger. With this move, Kelsen has seemed to some, including myself and Stanley L. Paulson, to have shattered the keystone of the pure theory, and in doing so, to have brought down the pure theory itself. Paulson explores whether the pure theory can be saved in neo-Kantian terms. I have, more simply, remained anxious. If the fiction turn threatens dire consequences for the pure theory, how does Kelsen appear not to see them? Perhaps he has perceived something that others have not yet noticed, and that could be of greater importance. I will offer an explanation of what seems to me to be plausible, and even if I am wrong about Kelsen, it may be fruitful more generally. The basic norm concept was introduced in order to describe how jurists register the legal character of positive law when they no longer acknowledge natural law. So what does Kelsen think natural law used to do? His answer appears in the second version of Reiner Rechtslehre almost in passing. A norm of natural law, he says, appears with its claim to exclude, auszuschließen, the possibility that a norm prescribing the opposite behavior could be valid. The value constituted by such a norm is described as absolute, in contrast to the value constituted by a norm posited by a human act of will. End of quote. Similarly, in the long essay on justice that is appended to the second version of Reiner Rechtslehre, Kelsen says of a metaphysical norm or ideal of justice, that it, quote, excludes its principle, fundamentally, the possibility of another ideal of justice, unquote. This norm of natural law excludes, schließt aus, literally shuts out. Kelsen had thought similarly about positive law long before, during World War I. Then, already conflating a sovereign state with a legal order, he holds that the legal order of a sovereign state, in its self-understanding, is characterized by unity as a system and by closure, Ausschließlichkeit. One state legal order cannot see both itself and any other state legal order as valid simultaneously. It regards itself as like, he says, the God of the Old Testament, the one and the only. It shuts out other sovereign legal orders as well as the possibility of subordinating domestic positive law to international law. In this account of a legal norm, the very possibility of an alternative is shut out, ausgeschlossen. One could say that the norm is closed. I will call this move taken in aggregate Kelsen's closure turn. Why does it not have greater prominence in the pure theory? Kelsen counted himself emphatically as a positivist. I think we know that. Adhering to two principles, to which I will give currently familiar names. Firstly, a positivity principle, that reality is solely sensuous and obviously there is no transcendent reality. Secondly, a separation principle, that statements of what is and what ought to be are different in kind, so that a statement that is of the one kind cannot be inferred from a statement that is of the other kind. Kelsen, like so many others, takes these principles to be self-evident and makes them central to his project of a purely descriptive science of law. In his eventual terminology, a legal norm, Rechtsnorm, is to be described in a legal proposition, Rechtssatz. However, he struggles to explain in what way this relationship is description. He shifts, it seems, between a legal scientific and a social scientific relationship. Shock? Yes. However, any lawyer, and indeed anybody when they think of law, is familiar with the conceptual difference between a statement of law and a statement about law. What is the criterion of that difference? When a state's legislature makes the law theft ought to be theft ought to be punished with imprisonment, this is a statement of law. Then others can say that in this state, theft ought to be punished with imprisonment, which is a statement about law. Although the two statements need to be identical or very alike in meaning, they are different in status. The statement of law is made with empowerment, while the statement of law is not. Statement about law is not. Another criterion of difference is ordinary almost everywhere else in the humanities and the social sciences. In these disciplines, the principle is so obvious and banal that it need not be articulated. However, its modes of application are debated. I shall term it an independence principle, that an observer's frame of reference ought, so far as possible, to be independent of the frame of reference of the observed. Applying the independence principle in the humanities and the social sciences, an investigator has to define their own frame of reference, and let this be called here the observation frame. Using that frame, the investigator defines a frame of reference that, so far as the investigator can discover, is used by the people observed. Let this be called here the observed frame. Kelsen does not explicitly adopt the independence principle. Until very late, effectively, he resists it. However, in 1966, in his article in the Israel Law Review, he appears to assume it. He says, "It is not the science of law which presupposes the basic norm. The science of law, which is a function of cognition, not of will, only ascertains the fact that if men consider a coercive order established by acts of will of human beings, and by and large effective as an objectively valid order, they, in their juristic thinking, presuppose the basic norm as the meaning of an act of will." And he specifies that a basic norm is a fiction in the extended Weinerian sense. By juristic thinking, remember that jurist means any kind of lawyer, he appears to mean anybody's thinking in terms of law. Here, the science of law has become an observation frame, and people's thinking in terms of law forms an observed frame. The presupposed basic norm now belongs to an observed frame. The general concept of a basic norm remains in the pure theory, now to be conceived as an observation frame. Since the distinction between an observation frame and an observed frame is grounded in the independence principle, it may be said that the pure theory has now undergone an independence turn. The pure theory of law enters what may be identified as a social scientific shift. Hans Kelsen has become a social scientist after his objections to sociology of law. We should not be very surprised, since he had been employed as a political scientist for the past 20 years. However, he himself only sets this shift in motion. He begins the process in Salzburg. Proponents of the Aristotelian Thomist form of natural law have shut him out. He has no opportunity for a fully reasoned response. Instead, he interrupts the discussion to impose on them a description of their point of view, so far as it makes sense to him. That is, as both falsehood and self-contradiction. What is said about a basic norm is necessarily also to be said about a legal order. The pure theory now has to be thoroughly revised through adding further the independence principle. Through these turns and this shift, it seems to me, Kelsen commences a new phase in his life's project of modernizing legal science. He's not abandoning legal science, quite the contrary. He's reinventing it again. He steps outside of most legal thinking, as it had been known. He makes himself an outsider to it. Taking further the old man's invitation, My chapter ends by suggesting that closure could be identified as the defining characteristic of a legal norm. Perhaps that is a new type of concept of law. Thank you.
Thank you very much, Professor Stewart. That was very, very, very interesting. Professor Heidemann? Heidemann is lawyer of the Schleswig-Holstein Bar Association. The floor is yours, Professor.
Thank you. Can you hear me?
Yes.
Okay, great. The concept of validity is a basic element of Kelsen's pure theory of law. However, there is a widespread suspicion that Kelsen uses this term to denote several distinct features: the existence of the norm, its binding force, its applicability, its membership in the legal system, or even its efficacy. I aim to show that this is not justified and that there's one central and clear meaning of validity in Kelsen's writings. The norm that X ought to phi is valid exactly if X really ought to phi. The first part of the text traces the genesis of the concept of validity in philosophy. The second depicts Kelsen's use of this concept, drawing on his Neo-Kantian texts. The third part demonstrates how the various features seemingly encompassed by this term in Kelsen's texts relate to this central concept. One of the earliest significant appearances of the concept of validity is in Kant's Critique of Reason. It is a result of the Copernican turn in philosophy instigated by Kant. Kant argued, quote, "I can compare the object with my cognition only by cognizing it. Hence my cognition is supposed to confirm itself, which is far short of being sufficient for truth. For since the object is outside me, the cognition in me, all I can ever pass judgment on is whether my cognition of the object agrees with my cognition of the object," unquote. From this, Kant concluded that a cognitive judgment is true not by virtue of agreeing with a given reality. Rather, it is objectively valid if it is constituted correctly, according to the rules necessarily guiding cognition in applying concepts to intuitions. That an object exists in a determinate way can be inferred from a valid cognitive judgment implying its existence, not the other way around. Quote, "The object always remains unknown in itself. If, however, through the concept of the understanding, the connection of the representations which it provides to our sensibility is determined as universally valid, then the object is determined through this relation and the judgment is objective," unquote. Hermann Lotze further developed the notion of validity in the mid-19th century. At a time when German idealism was in decline and the natural sciences progressed rapidly, Lotze used a theory of normative validity to assert the autonomy of philosophy and the humanities. In his teleological idealism, validity is the timeless mode of being of values. These values guide human cognition and thus, for an idealistic view, the way the world is. Validity is, for Lotze, a basic undefinable concept, and it is metaphysically prior to existence. Cognition aims at the value of truth, and the norms guiding cognition emanate from this value. The truth of any judgment is a product of its conforming to what we ought to think. The Baden school of Neo-Kantianism, represented by Wilhelm Windelband and Heinrich Wickert, took their cue from Lotze. To be an undefinable metaphysical concept pertaining as a special mode of being to transcendent values, the norms derived from them, and to those cognitive judgments which comply with these norms. They embedded it in a rational reconstruction of Kant's philosophy. This is what distinguishes their theories. In Kelsen's first major text, Hauptprobleme der Staatsrechtslehre, the influence of Neo-Kantianism is not explicit, but there's an emphasis on the dualism between is and ought, and on the distinction between the explicative view of natural sciences and the normative view of dogmatic legal science. The term validity does not play as important a role as in his later publications, and it remains opaque. What is certain is that the norm is valid by containing an objective ought. Validity means that the norm ought to be complied with and/or applied. Matters become ambiguous when Kelsen explains the specific legal concept of validity. Quote, if the norm derives itself in the form of a judgment, then it raises a general claim to truth, and it repeats itself in anybody who hears it, like any judgment. As a judgment, the proposition, if somebody steals, then the state wills to commit him to prison, is as true and universally, that is, for any reasonable being, valid as the proposition, the state is powerful, or the horse is a mammal. But this logical universal validity is of no consequence for the validity of the norm posited together with the judgment. Unquote. Here Kelsen appears to distinguish two types of validity, the theoretical validity of a cognitive judgment, which makes it true, and the ought validity of a legal norm, which makes it binding. But this distinction remains undeveloped in this early work. But then a review of Hauptprobleme prompted Kelsen to adopt a neo-Kantian foundation for his writings favoring transcendental idealism. Quote, as soon as we can no longer assume objects to have a knowledge-independent existence, cognition has to play an active, creative part in relation to these objects. It is cognition itself which creates its objects from the material given to it by the senses according to its immanent laws. What takes the place of metaphysical speculation is the task to determine the rules guiding the process of cognition, that is, the objective conditions of this process. Unquote. Following the Marburg school of neo-Kantianism, Kelsen framed his theory as a transcendental philosophy of law, beginning with the fact of legal science and replacing ontology by a presuppositional analysis of institutionalized legal dogmatics. The scientific fact is for him identical with the cognitive judgment of legal science. Such a judgment is, quote, the cornerstone of transcendental philosophy, which therefore can only be critique of science, critique of cognition, because it is restricted to analyzing the synthetic judgment, unquote. This clarifies the relation between the legal norm and the Rechtssatz as a cognitive judgment about the legal norm. Kelsen equates them with each other. Accordingly, the validity of the legal norm is its validity as an objective cognitive judgment. The norm X ought to phi is valid exactly if X really ought to phi, or if every rational being ought to think that X ought to phi. And the normative judgment, if somebody steals, he ought to be punished, is valid in exactly the same way as the empirical judgment, if a substance is heated, it expands, is valid. This is an example which Kelsen gave himself. So there are two different kinds of ought involved in any legal norm. The one is peculiar only to ought judgments and part of their content, which distinguishes them from is judgments. The other is the normativity which goes along with any valid cognitive judgment, obliging one to think this way. Now, a standard objection to Kelsen's conception of validity is that he uses the term to denote very different things, namely the bindingness of the norm, its existence, its being a member of the legal system, its applicability, and perhaps even its efficacy. This is, however, not the case. For Kelsen, from the perspective of legal dogmatics, it is true that one ought to act the way determined by the legal norms. This is validity as hypothetical bindingness. That the norm is valid means that, for the legal perspective, it exists as a normative fact, facts being nothing more than true thoughts. While a norm is valid exactly if it is part of the legal system, that is, if it has been posited in accordance with a higher norm, these notions do not mean the same. Membership is simply a criterion of legal validity. This also holds true for efficacy. While a legal system is valid exactly if it is effective by and large, because the basic norm is only presupposed if it is so, its efficacy merely conditions its validity. Finally, Boulligin holds that one aspect of Kelsen's concept of validity is applicability, and that norms not belonging to legal systems or norms which have not been posited in accordance with higher norms might still be applicable. Kelsen would probably reply that this objection assumes a conception of legal system which is different from the formal one he endorses. For him, any norm which ought to be applied necessarily belongs to the system of valid legal norms, because its creation and content in some way meet the criteria for valid law. A very short roundup. In Kelsen's neo-Kantian conception of law, legal norms are identical with the judgments of legal science. Their validity is the validity of cognitive judgments. That the norm X ought to phi is valid means that X really ought to phi. The sentence X ought to phi is true. It is a fact that X ought to phi, and every rational being ought to think that X ought to phi. Thank you very much.
Thank you very much, lieber Carsten. Our next speaker is Julieta Rábanos. Julieta Rábanos is postdoctoral fellow in theory and philosophy of law at the University of Belgrade. Julieta.
Thank you very much, Gonzalo. Also, I would like to thank the editors for inviting me to participate in this volume, which I think that is fantastic. I saw the index and I think that it is great in the sense of like it touches a lot of things regarding Kelsen, and also I think that it demonstrates the actuality of Kelsen's thought and the actuality of the necessity to consider Kelsen's thought and to discuss it, especially in some senses in regards to some trends in legal science, legal philosophy, and legal theory at this moment. So my chapter in the book is titled On Force, Effectiveness, and Law in Kelsen. It follows basically the idea of a debate that has been reactivated in maybe the last 10, 15 years, which is the relationship between law and coercion. The debate that had been something very important, I think, that maybe 100 years ago or maybe like 200 years ago, where it was kind of commonplace to think that law and coercion had an intrinsic, essential, necessary, in whichever way we think about it, connection. Then maybe in the last century, roughly at the half of the century, there was this turn in which maybe it coincided with a turn more towards an idea of metaphysically driven concept construction, where there was this idea about coercion as not being a necessary feature of law, because, for example, one very well-known argument is that we can think about instances of something that we could call law without thinking about the existence of coercion to denominate that law. And then there was a period of decades of abandonment about the idea of coercion or the discussion of coercion within legal philosophy. And then, as every trend or every fashion thing, it came back in the last maybe 10, 15, even 20 years. And then within this, my interest was to take Kelsen thought. I'm so sorry. Okay, it says that I switched to Italian. I am still speaking in English. Okay, fair enough. So Zoom was telling me, English. Yeah, so Zoom was telling me, oh no, you switched to Italian, confirm that you're speaking in English. Okay, fair enough. So basically within this, my idea was to try to come back to Kelsen, because Kelsen famously defined law as a coercive order. So my idea was to take Kelsen back, or in some sense going back to Kelsen. So the discussion about coercion, especially the one that is being held in these last 15 years, is concentrated on the one hand on trying to define this relation between law and coercion, and then naturally we can have a spectrum of positions in regards to this law and coercion relation. In one side of the spectrum, coercion as an essential element of law. In the other part of the spectrum, coercion as nothing related to law, or in some sense, or at least not a necessary feature of law. Then we also have a spectrum of understandings about what coercion is, from the broadest sense of coercion to the narrowest sense of coercion. But then also coercion is interesting to analyze because the property of coercion, or the phenomenon of coercion, can be used to answer all the four main theoretical questions related to law. The question of identity, like the question, how can a legal order or norm be identified? Also the question about efficacy or effectiveness, basically what is the criterion or condition for the existence of a legal order or norm, legal norm. Also the question about efficiency, how can law, for example, fulfill its function, whatever this function may be, and then naturally the question about normativity, which in some specific way to understand the question, it can be said superficially as the question about how law can guide human behavior or provide reasons for action to human agents. So why Kelsen? I did a spoiler, so why analyzing Kelsen within this discussion? So spoiler, I did before. Kelsen famously defined law as a coercive order, as a social and normative order, which was also coercive. And I think that Kelsen occupies a very important intersectional place within different theories or different ideas about what legal science, legal theory, and legal philosophy should be. We have already heard Professor Stewart explaining some approaches to the pure theory of law and the way in which Kelsen also turned or seemed to turn at the end of his work and his life, but also because when he was trying to construct his position, this was based in strong criticism, both to fact-based theories of law and also other enemies, as Professor Stewart was saying, which were like natural law theories or natural law lawyers. So he was at the intersection of these two ways to understand legal science and trying to maybe go in a third position, if we can say that. Also because his position can be taken as considering coercion to be a necessary element of law in both terms of function of law, in the sense of coercion as a means to achieve some type of goal that law can have or can be conceived as having, and also in terms of content, which is something that is very interesting because it was not only about maybe thinking of coercion as a means to achieve an end, but also as the subject matter of what you could consider to be a legal order, but especially legal norms. And then naturally also because his position was quite ambivalent, both considering and rejecting the analysis of coercion as motivation, in sense of like motivation of behavior, and also the analysis of the effectiveness or efficacy of legal systems as the most important fact for the analysis of existence and validity, both in regards to legal orders or legal systems and legal norms. So what I did in my chapter was basically to try to systematize and critically analyze Kelsen's position in regards to this relation between law and coercion. I tried to show in my chapter how the connection between law and coercion within Kelsen's framework can be seen as going deeper than this first definition of law as a coercive order seems to imply, which is deep enough, but I think it is deeper still. So what I try to show in the chapter is that Kelsen, or for Kelsen, coercion is an essential element of law in three ways. On the one hand, coercion of a specific kind is the distinguishing criterion between law and other social orders, such as, for example, morality or religion. On the other hand, coercion as a specific subject matter is the distinguishing criterion between legal norms and other kinds of norms, for example, moral norms. And the third way, which is maybe the most controversial, at least when I was writing, is thinking about coercion as an essential condition for the very existence of law, On the one hand, because it's essential for the effectiveness of a legal order, and on the other hand, because, and this is maybe the most controversial claim that I'm trying to argue within this chapter, because it's essential for the validity in itself of the legal order. And here I constructed or try to go within following two arguments. On the one hand, it's essential for the validity of legal order because the basic norm can be ultimately traced back to the principle of effectiveness. And this was something proposed by Norberto Bobbio from Italy. And then on the other hand, because even if we don't think about this traceability, let's say, to the principle of effectiveness in this way, because I think that the basic norm, at least in some formulations as proposed by Stanley Paulson, is nevertheless based on the notion of coercion. And so basically what I did in the chapter was following these steps. First, to analyze coercion between content and function of local social order, and then describe what type of or kind of coercion Kelsen was taking into consideration to say this is the criterion that differentiates between law as a normative social order and other normative social orders, which is basically physical coercion, which is socially immanent and then organized. The second step was trying to show how coercion is the specific content of subject matter of legal norms. And then here I undertook an analysis of this ideal linguistic form of the legal norm, especially the last formulation when Kelsen talked about the complete legal norm, which has the structure of a condition, which is an unlawful act, and then a consequence where there is an ought to apply a sanction. And then I analyzed this from an ex post perspective and ex ante perspective, as proposed by Paulson, in which from an ex post perspective, you can see legal norms in terms of empowerment to sanction or the authorization to sanction. Thank you very much. I was wondering, Gonzalo, how many minutes I had still, so thank you. And then to analyze it also from an ex ante perspective, which is analyzing legal norms, but in terms of the empowerment to issue norms that authorize sanctions. Nevertheless, looking in one perspective or the other, these norms, which we can identify as legal norms, have a certain object, which is sanction, and they deal with who imposes them, when they can impose them, or how they can impose them. And then Kelsen also thinks that sanction or sanction norms are the genuine, the complete, the primary, the independent ones. And the third step is basically analyze in which sense we can consider coercion to be essential for the existence of a legal order. And I was making the spoiler. I think that you can go into directions. One, to analyze how it might be essential for the effectiveness in itself of the legal order, effectiveness thought in the sense of the norms being by and large applied, and this can be thought in something that you can call effectiveness by action, which is the effective application of the norm by officials, and effectiveness by absence, which is basically that citizens or non-authorities are not performing the unlawful act. And then in this sense, I think that effectiveness is conceptually and empirically essential. Coercion is empirically and conceptually essential for effectiveness. Conceptually, because effectiveness is defined using the notion of coercion in some way, because it's defined by reference to these sanction norms. And then empirically, because you can think about the presence of coercion specifically in its indirect effects like the effects that it has on the minds of the citizens and also the officials in a narrow sense, can account for what I was calling effectiveness by absence. And then the last thing is to move towards this idea of coercion being an essential condition for the validity of the legal order. On the one hand, is because of this possible traceability going from the basic norm to the principle of effectiveness, and this boils down to the ultimate question about if you have two coercive orders in a certain place and a certain time that are more or less observed or in some sense apply with the norms that are being applied and obeyed in some sense, what of these coercive orders is the legal order? And Kelsen basically says the one that is more effective. That's it. That's the only thing that we can say. So Bobbio was, for example, proposing to think about if the basic norm in this sense could be, and I am quoting, an ingenious but ultimate completely useless expedient, something that we can do away with. And the second way to go towards this is to basically think about the different formulations of the basic norm, and taking into consideration the formulations that Paulson reconstructs in a fantastic article, and then this set of formulations regarding empowerment and legal validity, I try to show within the chapter that the 5 formulations that Paulson comes up with are nevertheless linked in some sense, either because they are based on the idea of coercion, either because they are related intrinsically with the sanction norm, and with this I conclude. If this is the case, then I think that we can trace back conceptually the base coercion and the basic norm, in the sense of the basic norm being another norm within the system having coercion in some way, directly or indirectly, as its specific subject matter. So this is basically my chapter. Thank you very much for the patience.
Thank you very much, Julieta. So we have 15 minutes for questions and comments. Who wants to start? You can do it, Julieta, if you want.
Okay, well, maybe this is an icebreaker, let's say. Thank you very much. I was really interested in the other presentations. I would have 2 questions, one for Professor Stewart and the other one for Professor Heidemann. I'm so sorry for my pronunciation of the name. Professor Stewart, I was really interested in the way in which you reconstructed these terms that Kelsen seems to do after the 2nd edition of the pure theory of law. And I sympathize with the idea that Kelsen went from this purity to something more related to social sciences in the sense. And I was wondering whether you agree, for example, with Paulson in the sense of that Paulson thinks that Kelsen started as a realist, then he had some neo-Kantian phase in which like the pure theory of law appears in some sense. And then in the last moments of his life and work, he went back to this realist way to see legal science, let's say. This is that there is an Italian professor called Pierluigi Chiassoni who thinks that from the beginning, Kelsen was a realist, and he kept being a realist throughout his life and work. So I was wondering whether you could say something about if you think that this might be the case, or if you think that there is something else than with this term. Because, for example, I think that considering Kelsen as an outsider in regards to legal science or the mainstream legal science, maybe he was not such an outsider, but just not mainstream in this sense, because there were other people doing this type of realist legal science. And my question for Professor Heidemann would be, I found the discussion about validity really interesting, also because it has, I think that when you were presented, I think that they say that you were a practitioner also, or a lawyer. Sorry for the confusion if this is not the case, but I think that the issues about validity have a very practical also application for practice. So my question would be, there is a professor in France called Mathieu Carpentier that basically thinks that Kelsen, it is not that he used the different senses of validity, but basically that validity is a cluster concept. So that is not the case that validity, or we can define validity as a set of necessary and sufficient conditions, but basically as a cluster of properties, for example, membership, applicability, bindingness in the strong sense, also what he calls conformity. So my question would be, do you think that maybe this is an alternative way to read what Kelsen was trying to do when he talked about validity? Or do you think that he still can be seen as having a specific definition of validity and other things connected in some sense to this definition? Thank you very much.
Professor Stewart, if you want to start. Your mic is
sorry,
off.
I think that you're muted.
Okay, can you hear me now? Good.
Yes.
Thank you very much, Julieta. I think the core of my answer to you is outside my chapter. It's in the article of 2023 to which my chapter is the sequel, which appeared in the Journal of Legal Philosophy. It was a review article of Thomas Chomsky's biography of Kelsen. And in that, I argue, as I've argued before, that Kelsen, without acknowledging it, takes over from Stammler a distinction made in Kant's theory of science, between a pure part and an empirical part of the science. The pure part is established as the ideas or categories, or not so much in the strict sense of categories, but the ideas upon which an empirical part can be based. The ideas of the pure part are applied in order for the empirical part to be possible. I take the pure theory of law to be a statement of a pure part of legal science in that sense. So when Kelsen begins to become more empirical in looking at the ways in which people themselves presuppose a basic norm, he's really supposing that he has a modification to his pure part, which makes possible an observation that they, in an empirical part, are doing that kind of thing. So I don't take him to be departing from neo-Kantianism. Not that he was ever a strict neo-Kantian. He said he was in Allgemeine Staatslehre, but he was never very consistent in his philosophy. It's true that he's not outside existing legal theory, in the sense he's outside of the realists, and his long debates with Alf Ross, which I hope to see in the Hans Kelsen Werke, in their correspondence, if it still survives, would show that. But let's think about how the Scandinavian legal realists conceived law. Did they, in fact, have a coherent concept of law, of the legality, the legal character of a legal norm? I would say they did not. They're still trying to get away from the more traditional conception of legality, to which Kelsen is an outsider.
Thank you very much. Professor Heidemann, if you want to.
Yes. Well, actually, I strongly oppose the cluster concept of validity because I think it doesn't do justice to Kelsen's texts. If we take a closer look at all those features which might be subsumed under validity, we will well soon see that they do not define validity. Membership, for example, is a criterion of validity, but there's absolutely no place where Kelsen says that validity is defined as membership. Validity is rather simple concept. Validity just means that one really ought to do what the norm says that one ought to do. So if the sentence X ought to phi is true, then the norm X ought to phi is valid. And I think this central concept is well persistent in all writings of Kelsen, really from the beginning, from Hauptprobleme der Staatsrechtslehre up to the general theory of norms.
Thank you very much. More questions or comments or may I? I found very interesting main part of the article of Julieta, and it is the relation between the classification between primary and secondary norms and coercion. I don't know if you could give us more depth about this relation that you name in your chapter.
Well, thank you very much for the question. This is an interesting thing because it is well known that Kelsen went from his idea of primary and secondary norms to his idea of independent and non-independent norms. And then in the last part of his life, he went back basically to the idea of primary and secondary norms, at least in some sense. So I think that the main connection between this and coercion is that in both classifications, either primary and secondary norms or independent and non-independent norms or dependent norms, the primary one, the genuine one, was the one that had a sanction of coercion or the use of force in the consequence of the structure of the norm. So basically, he went from saying that you had a primary norm which featured a condition and then a consequence, in which the condition was what it was called the unlawful act, and then a consequence which was an oath to sanction. And then the secondary norm, at least in the first formulation, was basically a reflex of this primary norm, in the sense of you ought not to perform an unlawful act. So basically, if you had something like, if you smoke, then you ought to be sanctioned as a primary norm. The secondary norm, which needed not to be enacted, it was a reflection, it was something that followed logically, if we may say that. And this, as Professor Stewart was explaining, this might be the turn against the application of logic to law can, in some sense, maybe explain why he then went in a different direction for the norms, and then he came back to the primary and secondary norms, but not in the same way. But this secondary norm was the reflection of the primary norm, and it was something that followed, which was basically you ought not to smoke. That was it. That was the duty. That was the definition of duty. And then when he moved to this idea of norms being either independent or dependent, basically the independent norms were the sanction norms, the norms that had the structure, that this hypothetical structure of if this is the case, then ought to sanction. And then the dependent norms were basically all the other norms that at this point he recognized that they were norms in some sense, and not just fragments, let's say, or these secondary norms that were the reflection. Basically, they were part maybe of the conditions of the application of the independent norms, or depended, and this is like the origin of the name, very original name, dependent norms or non-independent norms, on the sanction norms to either be applicable, either have some specific meaning, or either have some specific importance in regards to the legal system. So this is something that links coercion to this division between primary and secondary norms, and then independent and non-dependent ones. But I think that the most interesting thing is how this presence of coercion, or this idea of the hypothetical formulation with coercion as part of the consequent, had to distinguish between legal norms and moral, let's say, moral norms. Because for Kelsen, the primary moral norms were basically duty-related norms, in the sense of, in this like secondary norm sense, at least from the beginning. Basically, you ought not to kill. That's it. That's the moral norm. While a legal norm would be, if you kill, you ought to be sanctioned. So this also boils down to his ideas about techniques of motivation, direct and indirect motivation, blah, blah. But I think that this is the relation that I can explain briefly here.
Thank you. Thank you very much. So we are now in the second session of our presentation. Our next speaker is Lars Vinx. He's professor at Cambridge University in UK. So Professor Vinx, the floor is yours.
Yes, thank you very much for, well, first of all, giving me the opportunity to contribute to this volume, which I very much look forward to reading, and also thanks for inviting me to this workshop. So my contribution changes the topic a little bit. So as we all know, Kelsen was a very versatile author with very wide-ranging interests, and though he is best known, of course, for his work as a legal theorist, he was also a political theorist of note. And one of the most interesting aspects of his political theory is his theory of democracy, as laid out in a book that's called, in German, Vom Wesen und Wert der Demokratie, so the nature and value of democracy. And so what I try to do in my chapter is to explain why we should be interested today from a contemporary perspective in Kelsen's theory of democracy. And so what I try to argue in the paper is that Kelsen's theory of democracy offers an interesting response to the current crisis of democracy. So you're all aware, of course, that political scientists who observe these things are worried that democracies are in retreat, and that many democracies are moving towards becoming more authoritarian. And there's a perception that perhaps we are in a general crisis of democracy comparable to the crisis of the 1930s and the 1940s. But there's one important difference between the contemporary crisis of democracy and earlier crises of democracy, which is that the politicians or the powers that move towards authoritarianism in democracies today portray themselves as democrats, unlike fascists like Mussolini or Hitler. So they claim that what they're doing is to realize a purer, a better form of democracy than currently exists. So the major argument that's made here is that the democracy that we have, which is also referred to usually as liberal democracy, is a democracy in which the will of the people is constrained or is subdued or compromised by constitutionalism that puts limits on the outcomes of democratic decision-taking, limits that are enforced by constitutional courts staffed by judges who are not democratically legitimated in any way. And so the argument that is made by many populist authoritarians is that what we need to do is to free democracy from these constraints imposed in the name of liberalism, so that the true will of the people that is revealed in majoritarian decision-taking stands forth unencumbered. And so I think if you look at the political science literature and try to do that a little bit about such populist challenges to liberal democracy, then you find that some of the authors who write about this, they don't quite know. They seem unsure whether to credit populist challenges with being democratic or with making a point about democracy, or whether we should think that those challenges are in some sense anti-democratic and not just anti-liberal. So, for instance, you hear people like Carsten Heidemann say that, well, democracy is majority rule, but at the same time, these authors also want to hold on to the idea that liberal democracy, constrained democracy, is something good, which is threatened by populist movements. But I think this way of setting up the debate or of looking at the crisis is problematic because it concedes that populism is democratic and that the populist claim that democracy needs to be freed from liberalism has some merit. So if you think that populism is dangerous, as a threat to democracy, I think this is a bad way of arguing against populism, because you seem to beg the question against the democratic argument that populists make in just digging in your heels and demanding that liberal constraints on majority rule be observed. So how can we defend? That's the question, I think, that arises from this brief survey of the political science literature. How can we defend democracy against populist challenges without committing ourselves to a liberal understanding of constitutional restraints that might seem to beg the question against populist challenges? And I think it's here that Kelsen's theory of democracy is interesting, or can make an important contribution potentially to the contemporary debate. Because I think what Kelsen's theory of democracy illustrates is that even if you think that democracy is centered on majority decision-taking, on the majority rule, that a true democracy is a system in which the majority decides, you have to look more closely at the conditions under which decision-taking by majority rule can lead to legitimate outcomes. And I think once you do that, you can see that the populist understanding of the majority rule is deficient, and that it can be contrasted with, or it can be criticized by appeal to an understanding of majority rule that we find in Kelsen, and that is more friendly to the idea of constitutionalism than the populist understanding of democracy. So I take Kelsen to reflect on, in his work on democracy, on the question, well, how does a system focused on the majority rule, how does it have to work? What are the conditions under which it can generate decisions that even those who may find themselves among the outvoted in a minority, at least for now. So how is the system to be set up in such a way that those who are outvoted, who are in the minority, still have good reason to think that the outcomes generated by the political system are legitimate, where legitimacy is to be understood as giving us reasons to defer, at least as long as we are in the minority, to the decisions brought forth by majority rule. And so Kelsen has a number of interesting ideas about this question, I think, that if put together, give us a richer, a more nuanced understanding of majoritarian democracy than you find in populist understandings of majority rule. So you may be aware that the key argument that Kelsen offers for the legitimacy of the majority rule is that he thinks it is liberty preserving. And he argues that this is a feature of the majority rule that distinguishes it from all other ways in which binding collective decisions might be taken. So I guess another way in which binding collective decisions might be taken is to have laws made by an aristocratic body that includes only some citizens but excludes most of them. And if laws are made by an aristocratic body, of course, it is likely that the laws will reflect the interests of the people who are members of that aristocratic body, but will brush up against the interests of the large majority of citizens. And that, Kelsen says, will make people unfree in the sense that their own political preferences are going to conflict with the content of the law. Now, if we decide by majority rule, then Kelsen says we can rest assured, or there is a guarantee that well, though some people may find themselves being unfree in the sense that the law doesn't reflect their preferences, we will be assured that a majority of people, 50% plus one person at the very least, find their own preferences, their own political wishes in line with the laws that are made. So the amount of liberty that citizens enjoy in a democracy is assuredly larger than in other political systems. Now, this argument alone, suppose, doesn't quite get us to the point of being able to say that a decision taken by a majority must be accepted as legitimate by those who are not among the members of the majority, who are outvoted. So suppose that I am someone who is among the outvoted. I mean, the fact that most people, a majority, see their wishes realized in law doesn't seem to give me a reason to defer to the law. My own wishes, my own preferences are still frustrated. So the simple argument for the majority rule that Kelsen offers must be supplemented by some further considerations. And I think Kelsen is trying to do that in his book on the nature and value of democracy. And the key ideas that he presents are the following. So, of course, first of all, he would emphasize that in a democratic system, a properly democratic system, we don't just decide by majority rule, we do so in the context of free and fair political competition, where all members of society have a right to organize politically, to become members of parties that look after their interests, and of course to advocate for their political views in public, trying to convince other citizens to come over to their side. And everyone in a well-functioning democracy, of course, will have the right to vote, to participate equally in the process of decision-taking. Now, these background factors are supposed to give us a hope, at least. Kelsen thinks that even if we are outvoted at the moment, we may see our own view prevail in the future. And that leads to a second important background assumption that Kelsen makes. So for a democracy to give the outvoted reasons to defer to the decisions that have been taken, the content of the law must be revisable. So it must be the case that if my group, which we assume is not currently in power, wins a majority in the future, we'd be able to implement our political goals using our new won power to make laws that reflect our own preferences or interests. So if these conditions are fulfilled, then suppose even a citizen who is currently among the outvoted has the possibility to see themselves as a member of a popular will that's extended in time, and that at some point in the future, given that there is a normal alternation in power, will allow them to be among those who influence the content of the law, who make laws and determine policies. So Kelsen also points out, quite interestingly, that for this alternation to work, of course, the different camps in a democracy, the different parties must trust each other, that should they win an election, they will be allowed to take power. Should they lose it, they will step down, so that political competition can continue on free and equal terms indefinitely into the future. And Kelsen points out that for this to be the case, it's necessary for a society to be relatively homogeneous, not absolutely homogeneous, as Carl Schmitt might claim, but relatively homogeneous. So people must experience some degree of solidarity, some overlap of interests that allows for a peaceful alternation of government and opposition. And the general underlying idea is that if these preconditions are all fulfilled, the use of the majority rule will generate outcomes, political outcomes, laws that even those who are outvoted have reason to accept or reason to defer to. Now, this conception of democracy, of course, is developed in contrast with other conceptions of democracy, like Carl Schmitt's. And Schmitt's conception, I guess, is in some ways an anticipation of current populist rhetoric. So in the current populist understanding of the majority rule, which is also Schmitt's understanding of the majority rule, what the majority rule does is not to organize political competition that can lead to regular alternations in power. What it does is to reveal an underlying unity of a people that is already politically united. And it's only if the majority rule reveals this underlying unity that its use can be legitimate. So this idea, of course, reappears in present populist rhetoric, as Jan Werner Müller pointed out, in the claim that the majority are the real people, and those who are outvoted are representatives of the corrupt and hegemonic liberal elite that must be brushed away. So here, the idea is not that we live in a pluralist society where people can have different views about what policies should be adopted. There's an authentic people and there are its enemies. And what the majority rule, once it's disencumbered from constitutional constraints, does is to allow the true people to rule. So Kelsen, I think, opposes this understanding of democracy and of the majority rule quite compellingly, but he doesn't do so in the name, as someone like Dworkin does, in the name of a substantive liberal theory of the good society. He does it in the name of an understanding of the majority rule that I think is more compelling than the one we find in Schmitt or in contemporary populists. And that's not essentially tied to a substantive liberal ideology. So if that is true, then I think that Kelsen's conception of democracy does something very interesting in the context of the contemporary debate. So what it shows is that populism indeed is a threat to democracy, but it also shows that we can make this argument without just stamping our foots on the ground angrily and insisting that democracy must be liberal, which of course is precisely what the populist will deny. So what we can argue instead is that a democracy that's legitimating because it's a fair method of political competition must reject the populist tendency to identify a part of society with the whole, with the people as such. So Kelsen, in other words, offers an antidote, I think, to some current thinking about democracy that is troubling or problematic. And he offers an antidote to these trends that is more compelling or more convincing because it's thinner in its argumentative assumptions than the arguments that are typically made by defenders of liberal democracy. So closing with the plea that we should see that Kelsen is not just a wonderfully interesting legal theorist, but also an important and perhaps increasingly relevant political theorist and theorist of democracy.
Thank you very much, Professor Vinx. Professor Phil Edwards. Professor Phil Edwards is professor at the Manchester Metropolitan University. Professor Edwards, the floor is yours.
Okay, yeah, thanks very much for allowing me to be part of this this conference and indeed this collection. I'm going to be talking about Kelsen's concept of the primitive, particularly as it applies to international law. Now, the idea of international law as somehow a primitive form of law, primitive legal system, is one that predates Kelsen. It was common currency in the late 19th century, and generally by it, what people meant was simply that international law wasn't very well developed, that it would in future tend to develop, with a sort of inevitable progress of civilization, it would inevitably develop towards more structures, more formalization. It would, develop towards the norm represented by domestic legal systems. And Kelsen took hold of this idea. He very much latched onto this idea and ran with it. I mean, he argued that not only that international law was in a primitive state, but that it would, it would naturally evolve. It would recapitulate the process of evolution that domestic legal systems had already gone through, and so he believed that he could identify laws of history really applying to the development of societies and the development of legal systems in particular. And he developed this this theory most fully, although in a very idiosyncratic way, in the book Vergeltung und Kausalität, and the English version of it, Society and Nature, translated into Spanish, I believe, as Sociedad y Naturaleza, generally out of print, I think, in all languages. But in that book, he set about offering a history of the concept of causality, which seems to have nothing to do with any of what I've just been saying, but bear with me. His idea was that the idea of causality as A inevitably causing B, B inevitably following from A, was a kind of hangover from ideas of fate, ideas of destiny, ideas of religiously guaranteed inevitability, and which early modern scientists had got from Greek philosophy, and which Greek philosophy had got from Greek religion, and which Greek religion had ultimately got from primitive religion, as Kelsen called it. And so in Society and Nature, you have this monumental assemblage of data about primitive society, as Kelsen named it, and the various ways that primitive society works. And primitive society, Kelsen believed, was heavily dominated by retributivism, by the idea of retribution, that everything that happened was either a wrong which should be avenged, or else punishment for some wrong that had already been committed. If you went hunting and you didn't catch anything, that was evidently punishment for something that you'd done wrong in the past. So anything could be explained in those ways. And he tracked that forward to the development of sort of similarly rigid ideas of causality. It's a very strange book. The interest that it has now, I think, is in the way that it developed this idea of universal retributivism. He argued that in what he persisted in calling primitives, I mean, the idea of the word primitive was rather outdated and, bordering on racism even at the time, and it's certainly not really usable now. So I just have to put quotation marks around it every time I use it, generally with my fingers. And so his idea was that primitive societies were utterly dominated by this idea of retribution, that retribution would be spontaneously meted out by the community as a whole, and without any sort of pause for thought or deliberation, without any possibility of appeal. And he argued that this represented a legal system, a system of law. He argued that the very fact that blood feuds can be seen very early in the development of human society demonstrates that that human society had, moral institutions even at that early stage. He considers the blood feud, the vendetta, as the origin of justice, as we now know it, and draws numerous parallels between the characteristics of primitive societies, such as the vendetta, such as meting out revenge.
Cuando nos indiques, Gerardo, por favor.
Sí, doctora, está haciendo la conexión, permítame, por favor.
Gracias, muy amable.
Listo, ya podemos retomar, por favor.
Gracias, Gerardo.
So thank you so much for bearing with us. It seems that we had a technical problem with the Zoom platform. We don't know exactly what happened, but Professor Phil Edwards is not with us at the moment. And he was the last one, right?
He was the last one. We can start with the debate and
yeah,
the questions.
Let's wait until if Professor Phil joins back. But on the meantime, we can start with questions for Professor Vinx, that he just joined us, and with a more general discussion about the future of Kelsen studies, if that is appropriate. So, are there any questions for Professor Vinx while we wait for Professor Edwards? Julieta and Gonzalo.
Well, thank you very much for your presentation. I find it really interesting to know that there is a chapter in the book that is like thinking in the same direction as myself, in the sense of that Kelsen has things to say that are absolutely applicable to current crisis debates, and specifically this thing, because I agree with you, and for the Zoom I am still speaking in Italian for some reason. I agree with you that Kelsen's ideas on democracy and also justice are not really taken into consideration, and they are huge. And I think that they are underlying also some of the things that he was doing when he was doing legal science in a specific sense. But my question goes to something that I think that you said when you were trying to analyze the way in which Kelsen tried to integrate the argument in regards to the majority rule. The second thing, when you said that law needs to be revisable. And I heard that you were using revisable in the sense of replaceable, just in the sense of as a decision of the assembly or the parliament. But I was wondering whether judicial review of the law is also a condition that needs to be taken into consideration, and if this fits within the argument of law being revisable or not, because I think that was also connected to something that you were arguing for, which is the idea of democracy as a legitimate system of alternation of power. And it seems that judicial review in that sense does not really fit in the same way. So I don't know if I could explain my point, but I was really interested in the way in we are reconstructed it. So thank you very much.
Yeah, should I answer right now, or?
Yes, please.
Good. Yes, I think this is a question that I'm struggling with myself. So, and I'm trying to give a good answer on behalf of Kelsen, but I'm not sure whether I have a really good answer. So, it seems to me that there's a tension between, on the one hand, his defense of democracy, and in particular this major argument about how the majority rule is freedom preserving, on the one hand, and on the other hand, his advocacy, which of course I didn't talk about, but which is important as well, of constitutionalism and of judicial review. So of course Kelsen was a judge on one of the first constitutional courts, and he wrote a number of interesting pieces advocating for the introduction of constitutional courts and jurisdictions where they didn't exist. And it seems to me that if you have a formal constitution enforced by a constitutional court, then you give rise to the what Americans call the counter-majoritarian difficulty, and you will find yourself in situations where the will of the majority is frustrated by a constitutional limitation as interpreted by a constitutional court, and that seems to give rise to the prospect that a majority of people will find their own political preferences frustrated by the decisions taken by a constitutional court. And that does seem to be a major tension in his constitutional or political theory, which restrains the revisability that I think is important for democracy to be legitimate. So how to try to mitigate this tension in Kelsen is something I'm not really sure about. But I take it that one way to try at least to mitigate the tension is to argue that, first of all, that a formal constitution should not go overboard as many modern constitutions do in adding a long list of substantive liberal rights into the constitution itself that then form barriers to majoritarian decision taking. So Kelsen himself, in his writings on constitutional review, says that ideally a constitution should abstain from putting too much moral content into the text, and it should be a procedural document. And of course, this is then related presumably to the idea that a constitutional court, if the constitution is procedural, could limit itself to policing procedure, and in a sense to making sure that fair and free democratic political competition and the rights that are necessary to enable it is preserved. And it seems to me that this is the kind of judicial review that he was thinking of, and that perhaps would have made his democratic theory compatible with constitutional review. But so I guess the problem is that though his theory of democracy is very timely, perhaps his understanding of constitutional review is not very timely, or it doesn't fit the practice of constitutional review that we are faced with today very well, because that practice is much more morally ambitious than Kelsen thinks constitutional review should be. And I guess that's the problem that we are stuck with today from a Kelsenian perspective, that constitutional review has developed in a way that highlights the tension with democracy instead of mitigating it.
Thank you very much, Professor Vinx. We can restart the exposition of Professor Edwards if Professor Edwards wants to join us.
Okay. Yeah, should I go from the top? No, we'll do that.
The last thing was vendetta or vendetta.
I'm sorry?
The last thing, it was about blood feuds or vendetta. And that was it.
Yeah.
And Zoom just exploded.
Yeah, I don't know what to read into that. Okay, so yeah, I was saying that Kelsen, presented this. I mean, he read a mountain of ethnographic literature, most of it quite dated, and from it sort of synthesized this model of what he considers primitive society and the primitive mentality to be. And as I say, it's dominated by the notion of retribution. Whatever fate threw at you, then it was right and appropriate and necessary to take revenge on somebody or something, just to kind of keep the scales balanced. And so as ethnography, it was terrible. He made no distinction between different continents, different centuries. He had this sort of fixed idea that there was something called the primitive mentality, and he ascribed everything to that. And the notion of inevitable evolution into civilization is also extremely dubious. But what remains interesting and relevant and even useful is the idea that what he was describing there can be seen as the basis of a legal system. The idea that you can see law as this immense continuum, and or several scales, with extreme informality, extreme decentralization, irrationality at one extreme, and gradually increasing centralization, formalization, and so on, as we get towards the modern day. I think this is still quite a powerful frame of reference, because it sort of puts flesh on the bones of this idea of international law as primitive. If you can say, well, there used to be these primitive societies where people didn't ascribe responsibility to individuals, where people didn't take account of motives, they just reacted retributively. And look, here's international law. You can't sort of think in terms of mens rea in international law. You can't think in terms of individual mentalities. It's just one state against the other. And so Kelsen could argue, there we are. That's what you'd expect of a primitive legal system. I think this is interesting and powerful stuff, because it simply greatly expands the notion of what a legal system can be. It doesn't have to have any centralization. It doesn't have to be sort of rationally organized even. It can be very, very nebulous, and based on tit for tat, revenge, vendetta. It can still be qualified as a legal system. The interesting, what I tried to get into in my chapter as well is the place of this sort of late 30s, early 40s diversion in Kelsen's work overall, because I think he really felt that he sort of hit something with this idea of primitive, diffuse, informal legal systems, and with the idea of evolution into centralization or formalization, and so on. The problem with it is that one of the things that he thought was irrational, as well as lack of centralization and so on, was retributivism itself. And the whole notion of retribution, in fact, he regarded as unscientific, irrational. I mean, he was enthralled to this idea of science as rational and science is based on cause and effect and so on. But you know, once he'd sort of got it into his head that there was something irrational about retribution, along with these other features of the primitive legal system, I think he found that an immensely unsettling thought, and found it very difficult to develop. I think that, you know, the implication of the primitive model is an implication he developed in a couple of sort of sporadic. He made a couple of sporadic attempts at developing this, but not in any of his main texts. The implication was that there was actually something irrational about the norm. You know, the norm as he'd conceptualized it had this seed of retributivism, had this seed of irrationality about it, and it would need to be reconceptualized in purely rational terms. But I think having set himself that challenge, however informally, he recoiled from it, and so we get the slightly theoretically thin text of the post-war period, the general theory of law and state, and the very sort of abstract and involuted second edition of the pure theory. So you know, it's still a fascinating side turning, really, in Kelsen's work, particularly, you know, if you're interested in the question of how international law can exist, you know, what's specific to the conditions of existence of international law. But this whole sort of primitive international law theory was very disruptive for Kelsen's thought, and arguably it's a challenge he never really digested, perhaps until the 60s. And I'll leave it there.
Thank you very much, Professor Edwards. So we can open our round of questions and comments. Jorge? Oh, Julieta, if you want, and after Julieta, Jorge.
Yeah, it is a very small question because thank you very much for your presentation. I am really interested in these topics, specifically because I was involved in some analysis of legal evolution and legal evolution of legal systems. So this perspective that you're giving me of Kelsen's work in regards to primitive societies, and it was fantastic. So thank you very much. My question would be, how do you think that fits coercion in this? Because when naturally we're analyzing or at least when trying to analyze the role of coercion, at least in the more maybe traditional settings of the works of Kelsen, naturally it seems that coercion has to do with the state law, or at least a legal order just considered as a national level. So he has this criterion of distinguishing between a legal order and blah, blah, because of coercion of a certain kind. But it seems that there is no such criterion at an international level. So my question would be, and naturally it disconnects in some sense with retributionism, because it seems that if you're like trying to retribute something, it might be considered to be, okay, you're doing it to arrive to the situation that was before the wrong. So it might be not punishment, but then reparation, or you go with punishment. But this, I think that it's not what is in his mind when he talks about coercion, at least at a national level as well. So what do you think about that? Thank you.
Yeah. I think I think he saw coercion as absolutely definitive of law as a system of norms. I really do feel that he recognised that there were multiple normative systems in the world of religion and morality and so on, and what made law was that it was a system of laws, a system of norms backed by coercion, and what's interesting in Society and Nature is that as I say, he generalizes this back down to situations like the vendetta, like blood revenge. So he argues that you don't have to have any kind of centralized authority to have a community, a community capable of wielding coercion. He actually says that when a group within a community carries out blood revenge, they do so with the implicit blessing of the community, and as such, their violence is monopolized by the community. So although it doesn't appear as if the community has a monopoly of force, actually it does, in this sort of rather abstract sense. So he's very keen to sort of bring those two things together. And I guess on the international plane, you could argue something similar, that the community of nations endorses the idea of retaliatory violence, and so in a sense that violence is monopolized by the community. I think that's probably how you would argue it.
Thank you very much, Professor Edwards. Jorge, do you want to ask? Because you had your
I certainly
Microsoft.
do, and I have lots of questions for all the speakers. So, one thought, one for Professor Vinx and one for Professor Edwards. I have a similar thought about judicial review, but for Professor Vinx, like Julieta. But my other question is about the homogeneity conditions for democracy. So that when Kelsen says that, there is something strange about that. On the one hand, that could be read as a like a factual limitation. Like if people do not think alike, or if cultures are too dissimilar, we couldn't have real democracy. But it could be read like a normative condition, like real democracy demands certain degree of homogeneity. So which of the two readings seems to be the more accurate, and does it contradict to some extent the idea of normativism? Because one reading is just like community are the people who follow the same norms, and that should be enough. But now he's saying they have to have certain kind of. I'm like without if you ask me without reading your paper, I would say no, it's about norms. People agree with the norms, and that's it, and that's all we need. But you need something else. So I'm curious about that. So I'm with Professor Edwards. I really find the discussion of that forgotten Kelsen, the society, fascinating. And the more I read your paper, the more I think it's how much should we take that part, the society and nature, as integral to the pure theory? No, this is just Kelsen taking his hat off, just Kelsen doing something for fun, doing something different. This shouldn't be illuminating the pure theory. Or this is just sociological speculation. Kelsen is just or how can it be illuminating the pure, the same concepts that appear in the pure theory appear there? And second, do these ideas then contradicts the purity? There is a sense of theology that he on the one hand said in the pure theory, no, we are not looking for those values, ideologies, but here he seems to have a sense of goal, purpose. So is it the same? So the question is not about the reading of primitive law that you illuminatingly explain, but more about how do we read Kelsen? How do we read these different pieces? Do they fit together? Are they two different things? Thank you.
Okay,
Professor
so I'm
Vinx?
going to just give a brief answer. So I think that it must be a factual condition. If it was a normative condition, it would turn Kelsen's view into Schmidt's, because if it's a normative condition, then there must be someone who has the power, in some sense, the legal or the political power to enforce that normative condition of homogeneity, and then you end up with something like a Schmittian conception of constitutional guardianship or sovereignty, which of course would be incompatible with Kelsen's understanding of democracy. So I think it must definitely be a factual condition. But there's an interesting further twist to this. So he talks about relative homogeneity, Kelsen. And later this term shows up in Hermann Heller's Staatslehre, and there's a reception of this in post-war public law in Germany, and people like Birkenförder and so on, who are followers of Schmidt, but who appeal to Heller in order to introduce this normative understanding of homogeneity using the same terminology. And I don't think people have realized that Kelsen uses this terminology long before Heller does. And I think it's something I need to look into a little bit more. But the answer to your question is factual, not normative.
Yeah, on the point about how to make sense of society and nature, how to fit it into Kelsen's career, I think there is a tendency among some writers to sort of put text like that off on one side, to say that Kelsen was this great legal theorist, and he gradually refined his theory over the two editions of Pure Theory and so on, and he was also, and he also had these interests in politics or in sociology, and he sort of indulged in these things. I think it's much more interesting to sort of fit it all together, and I do think I do think it potentially fits together with the pure theory as he developed it up to then in quite an interesting way, specifically focusing on international law. I mean, I have to be quite cautious, because when obviously Kelsen devoted a lot of time and attention to international law after the Second World War, and when it came to things like what would be the basic norm of international law, his formulations were really quite cautious, quite unimaginative, I would say. I think he didn't want to sort of lose credibility as an international lawyer, really, by coming out with all this wild stuff about, hey, what this reminds me of, it's Papua New Guinea or something. But I do think that if you read what he says about primitive legal systems as providing a model for international law in particular, it's actually and the minimum conditions for a legal system in general, it's actually really potentially a really interesting extension to the pure theory, although one that he himself didn't really take on board.
Thank you very much. Jorge, there is something that you want to add, or we can just finish our session, because we are done with the time. You are muted.
I have more questions, but yeah, it's beyond time, and it's like midnight in Germany.
But there is no problem with me. I mean, it's only for the organizers that I'm a little worried. But if you want,
no,
because I have questions too.
Don't worry, it's okay.
It's okay. So do you want
Yes,
to
it's okay.
Thank you very much.
Oh, you're welcome.
Perhaps we can take 3 minutes more or something like that. If you want to,
you go first, and then I have a question for everybody else. Yeah.
Because there is something very interesting that I found in the article of Professor Vinx, is the interchange between individual freedom and compromise. The canonical interpretation of Kelsen that, as far as I understood, is that the concept of a democracy is based on a political freedom. But at the same time, what you rescue in your article, in the chapter, is that this political freedom is impossible without compromise, and the compromise is impossible without individual political individual freedom. So, do you agree that it is possible to state that perhaps what the new populism movement want to attack is exactly the compromise, with the political compromise with the political freedom that is needed for democracy?
Yes, I think in the article, to be perfectly honest, so again, I find it difficult to see exactly how the notion of compromise is supposed to work and how it relates to this argument about freedom. So presumably the idea must be that compromise is especially important when there are groups that are never going to form a majority. So for example, if you have a religious or a national minority that will never be part of a governing coalition, then it must be endowed with certain constitutional rights that protect its interests against the majority. And that seems to be, again, going back to the discussion that Julieta started earlier, I mean, that seems to stand in tension to some extent with the defense of the majority rule in Kelsen. And so I think what I tried to do in the article is to fudge this a little bit, if I'm honest. So if you found that convincing, I'm very glad to hear that. And I think the answer to your question is yes. Obviously, the populist movements are built or they're committed to the rejection of compromise because the idea is that that there's a true people and that it's united in its interests, and really what the goal of democratic politics should be is to remove restrictions on the expression of that united will, which presumably are entailed by constitutional restrictions, but also by pluralism within the political system that's welcomed in Kelsen's conception of democracy. So yes, so I think the answer to your question is yes, in short.
Thank you very much. Jorge or anyone who want to?
So because I have this rare opportunity of asking this question in public, I'm gonna take it, and then we can rest for the day. So I have one question for Professor Stewart, one question for Julieta, and one question for Professor Heidemann. So for Professor Stewart, it's like two questions. One of them is about the fiction term. Something that I have. So there is this philosopher that has this idea, like, let's imagine jazz if John Coltrane didn't happen. So something like that. So let's see what would happen. At the last of your paper, the last section, you mentioned that we haven't taken the fiction term seriously. That's something like all these scholars, they haven't taken it seriously. Would legal theory be different if we would have taken Kelsen's fictional term different? We have taken the fiction term seriously. That's one. My second question is about the beginning of your paper. So in the first part of your paper, you have this really, really nice story about the Salzburg meeting. All these natural lawyers, some of them with authoritarian tendencies, talking to Kelsen. So my question is about the project of legal positivism, because when we're reading all these Salzburg natural lawyers in the paper, it reminds me a bit of the contemporary natural lawyers, like the people like the common God constitutionalism. So, and the question is about positivism as a project. Are these Salzburg's natural lawyers back again? And is positivism necessary for responding to this kind of like neo-natural lawyers? So for Julieta, so One question I had is about the concept of coercion. Sometimes it's narrow, sometimes it's wide. I thought you have like a wide understanding of coercion, but the more I listen to your question, it seems like coercion is wide. And I'm sure you know, like John Gardner's response to Kletzer. You saw like, what is exactly coercion? Does it demand physical force, and or not? Because in your question, it sounds like, no, we need physical force. That's real coercion. But also like, what would be your take when coercion is outsourced? For example, like lex mercatoria or arbitrarial awards, they don't have coercion, but they are necessarily enforced to the state. So, and that's an argument against like lex mercatoria as a legal system. It's not real, it's just enforced through others, something. So I would like to know what you think about that. And my final point is to Professor Heidemann about the idea of validity. So at some part in response to Julieta and also in the paper, there is this idea of validity and applicability in the paper. And you mentioned that in order to grapple with this distinction of validity, applicability, when you're talking about bullying and the idea of applicability, you say that there are two different concepts of validity. So two different concepts of legal systems at play. One for bullying, one for Kelsen, and they are talking past each other. So that made me think about the idea of validity that we're discussing. So it's only for Kelsen, or does it apply to other theories of legal system which are not Kelsenian? Or do we need to understand legal system before we can understand validity? I hope that makes sense. So thank you so much to everybody for your patience with me.
Professor Stewart, your mic is off. Professor?
I think I'm unmuted now. Thank you. Sorry to make the same mistake again. To the first question from Jorge, what difference would it make if, would it have made if people had taken the fiction term seriously? The problem was that most people were not sure what it meant. And I'm still not entirely sure what it meant. I'm not entirely sure what is the contradiction. So what I've done is to take it seriously, and it has taken me out to another dimension, which is the dimension of closure. And other people might have gone that way, maybe not, and I can't speculate. Your second question is about legal positivism, and I can only answer a little bit of that. And I'll expand on what I've said today, and which is also in the chapter. What are the consequences of taking law as closure for the idea of natural law? Natural law counts as a social phenomenon. Just like positive law, both of them come under the concept of closure. But natural law surely doesn't have coercion. Yes, it does. If somebody is told, if you steal, you will go to hell, and they believe they will go to hell, they are coerced. Because coercion, let's go back to John Austin, always orders backed by threats, and is usually criticized on the count of orders, commands. If we say threats, he's right. What matters is not the availability of coercion, but whether the threat is believed in. And so natural law has all kinds of threats, and if they're believed in, natural law is effective. I think we can see, not just back in the Middle Ages, but today, natural law is very effective. And for legal positivists, in that sense, to dismiss natural law and say it doesn't matter anymore is empirically wrong. It is there, it operates in society, and we have to take it into account as a social phenomenon.
Thank you very much, Professor Stewart. Julieta, if you want to answer for his
Of course, thank you. I will try. Thank you very much for your questions. And I'm sorry if my answer would be terrible in the sense of I think that my brain is not braining at this hour. So, but basically, like the short answer is I am not using a specific concept of coercion in the paper or subscribing to a specific concept of coercion in the paper, because I am just limiting myself to what Kelsen seems to say about coercion. And what Kelsen seems to say about coercion is basically that there is psychic coercion and there is physical coercion. And then he thinks that the marker of a legal, so the type of coercion that distinguishes legal orders from other social and normative systems is the presence of physical coercion. He says that, and this comes back also to what Phil was saying, and also Iain is saying right now. So it goes back to the idea that in every social system, or social order or normative order, but especially social order, there is some type of principle of retribution. So some type of coercion exists in every social order. The marker between a legal order and other orders is basically that in specific case of legal orders or law, physical coercion is present. In the other ones, psychic coercion, and then within also law, there is psychic coercion that disconnects with the answer to the precedent question that you were giving. And it is in some sense also connected to what I mentioned superficially about the indirect effects of coercion, in the sense of like indirect effects of the existence of the probability of being applied physical coercion, which is one of the markers, I think, that goes down with this psychic coercion in regards to legal orders. And I think that also connects with something that I asked Phil about coercion in international level, international systems. And I think that if you construct it the way naturally, I don't think, and this was also something that I was wondering, the idea that the marker is physical coercion, it makes you think that there are some specific subsets, let's say, of international law, which couldn't be considered as some type of legal orders. But then if we go back to something that Iain was saying, they are parts of a whole system that in some sense is linked to coercion and is backed by coercion, and it's backed also by physical coercion or the threat of the possibility of that. So I think this is the thing that comes to my mind right now in regards to this. And it also like boils down to a question about whether the marker of coercion in regards to a legal order is centralization or organization. In the sense of, I think that the marker is organization, like the rules of the system says who, when, how. And this is absolutely compatible with the fact that this might be not centralized or not public, in the sense of maybe, for example, allowing private actors to exercise coercion. For example, this, and going back to Phil, blood feuds, or like private actors having some vendetta but being ascribed or imputed to the whole society afterwards, because the system authorized that type of coercion. So sorry for the answer, but yeah, thank you very much for the question.
Thank you very much, Julieta. Professor Heidemann, are you there?
Yes. Well, it's late. I'll try to make it short. Well, I should say that applicability implies validity. If a norm is applicable, it must be valid. And again, if it is valid, it must be, at least for a positivistic view, it must be part of a system, of a legal system. But I wouldn't say that system is prior to validity. In fact, it's a kind of relation of equiprimordiality. You cannot have the one without the other. No system without norms, no norms without a system.
For my part, I want to thank you, everyone, for being here. And I don't know if Jorge wants to close our session.
No, I just wanted to say thank you so much for your patience. Thank you so much for, I will apologize for the technical errors, but it has been fantastic. To the contributors, thank you so much for your wonderful contributions, for working in this excellent volume that we plan it to be a contribution to the Kelsenian literature as big as the William Twining, the William Twining paper from the, edited volume from the 80s, or the more recent Kelsen, Green and Duarte. We wanted to do something like that, and I think we achieved it, and it wouldn't be possible without your support, patience during this long process, and availability for having this conversation. So Kelsen is truly a global jurist, and the community working is truly fascinating. I just like willing to continue to talk over half an hour extra, and I should stop now. But thank you so much.
Well, thank you very much, Jorge, Gonzalo, and all the speakers for this fascinating discussion and for sharing with us the core of the ideas that you have exposed in your contribution in this extraordinary book. Thank you very much. We'll see you. And para nuestros compañeros que están todavía siguiendo las jornadas, los esperamos mañana. Vamos a tener también un día muy interesante, una mesa sobre pluralismo. Y en la mañana tendremos algo sobre escuelas críticas del derecho, que espero sean críticas serias. Así que bueno, con todo gusto, que pasen ustedes muy buenas noches. Hasta luego.